Suzanne, I think we're good to begin.
Yes, I would say so. I think people are still dropping in and will probably do so over the next minutes, but I think let's get started. Welcome everyone to today's webinar, where we'll be focusing on cooperation over shared freshwater resources using international law. We have about 90 minutes to discuss this topic, and I'll be the one who guides you through today's seminar. My name is Susanne Schmeier. I work at IHE Delft, which is the UNESCO-founded Institute for Water Education in Delft in the Netherlands. As I said, we'll have 90 minutes to discuss this, and this will consist of a short introductory presentation by two people who were fundamental and really crucial for getting this specific book, as well as the bigger edition of books that this book is part of, into being. And they'll share a little bit about the books in general with you. And we'll then have a discussion with some of the authors of this specific book about what their contribution is to the book, but also what their main message is when it comes to the role of international water law in managing shared water resources, shared freshwater resources, what we think we learned from the process of writing this book, and which messages we want to share with you. Before that, as I said, I would like to hand over to the two editors. I'll start with Shlomi, who is the editor-in-chief of the overall volume of this World Scientific Handbook of Transboundary Water Management, Science, Economics, Politics, and Policy, of which this specific law volume that we're discussing today is one part. Shlomi is the Dean of the Stephen J. Green School of International and Public Affairs and a professor at the Department of Politics and International Relations, both of that with Florida International University. And without any further ado, Shlomi, I would hand over to you to introduce the overall 4-volume project to us.
Thank you. Thank you very much, Suzanne. Good morning, good afternoon, good evening, depending on where you are across the world. As mentioned, I have the honor to be the editor-in-chief of this 4-volume set, of which the volume we'll be discussing today is featured. I'm, in fact, grateful to Gabriel Eckstein, the editor of this specific volume, for putting this webinar together, as well as the many co-sponsors of this webinar, and of course, including our publisher, World Scientific Publishing. So let me just start with the motivations for this 4-volume set. As many of you know, the impacts of population growth, climate change, and water scarcity and variability on a given country's economy or society has made the management of transboundary fresh water, and here we're referring to rivers, we're referring to lakes, underground aquifers, it's made it a subject of great import. And this has been further complicated by the sheer need to harness an international freshwater body for domestic or basin-wide purposes. Over the past several decades, research across various disciplines has explored such issues, focusing on freshwater's strategic importance and as a resource that has simultaneously elicited conflict, negotiation, and cooperation. In fact, a multidisciplinary approach to the study of transboundary freshwater can better contribute to its more effective management. So, our multi-volume set seeks to contribute to this still bourgeoising body of literature by focusing on several key themes that can help explain and recognize successes and failures in transboundary freshwater management. In particular, the 4-volume set seeks to bring together original scholarship focusing on international water law, technology, institutions, formal and informal institutions, as well as the interplay of domestic and interstate affairs. Each volume in the set aims to build on extant literature, while also fostering new paths of inquiry. Overall, we hope that the set will become a guide for academics, students, and practitioners hoping to better understand the joint management of this precious natural resource from various disciplinary perspectives, approaches, and methodologies. So, as we know, the first volume, which is on international law, which is edited by Gabriel Eckstein, but I will not go into detail here in my own remarks. You will get to hear from Gabriel directly and as Suzanne mentioned, from some of the contributors to Gabriel's volume. So the second volume in the set is edited by David Katz and considers the nexus of technology and transboundary water management. The volume itself consists of chapters that emphasize the potential for various technological developments to facilitate transboundary cooperation over water and wastewater by, for instance, alleviating water scarcity, assisting in data collection and sharing, allowing for joint monitoring, regulating flows, and mitigating pollution and contamination. At the same time, the volume also offers a critical perspective, warning that over-reliance on technological fixes may obscure underlying structural, social, and political issues that are at the heart of sustainable international water management. The volume concludes that technological innovations and advancements serve to make water management more effective, but also highlights the limitations of technology to reshape how water is managed. The third volume is edited by Neda Zawahri and focuses on institutions as a mechanism for managing conflicts and fostering cooperation over shared freshwater resources. Her book considers formal institutions that include such examples as international water treaties and river basin organizations. The book also includes an analysis of so-called informal institutions that operate at the subnational, domestic, and transnational levels. Such informal institutions differ from formal institutions in that they may not have formal legal authority, but often provide a level of order and contribute to the management of a shared water body. The volume concludes that formal and informal institutions function independently of one another, or may also be nested, or if you will, occur simultaneously. These variations in institutional dynamics often offer different lessons for water conflict, cooperation, and management. The fourth volume in the set is edited by Yaron Warner, who explores the complexity of managing shared freshwater across borders at the interplay of international, transnational, and domestic river governance. Said differently, Yaron's book explores conflict and cooperation over shared freshwater from a multi-level perspective. In so doing, the analysis not only assesses how states engage in a hydropolitical game, but also how that interaction may be impacted by foreign or transnational actors, as well as domestic dynamics. These levels of analysis are not necessarily mutually exclusive, but are rather interdependent and often occur simultaneously. Such a layered analysis can be very helpful in trying to understand progress or lack thereof in the management of international water. So allow me, as I conclude my remarks, by saying that since the management of international freshwater is best understood from a multidisciplinary perspective, such an approach highlighted in a single compilation is one of the main contributions of our set to both scholarship and practice. The volume themes, again, international law, technology, institutions, and the interplay of international and domestic politics, provide another noteworthy contribution, since these overarching topics make up both existing and emerging areas for assessing fresh water management. It is our hope that the set and the lessons provided in each volume advance our understanding of transboundary freshwater management and contribute to its effectiveness. I am extremely honored and proud that the volumes in this set are edited by leading scholars in the field who hail from different disciplines, and the same is true of the chapter contributors. You will now be hearing from some of them in the remaining of this webinar, and again, thank you so much for this opportunity. Thank you.
Thanks a lot, Shlomi, for giving us this overview. And I think it's really interesting to see how we have this specific book focusing on law that we're discussing today, but how this is embedded in a bigger picture with 4 different volumes that you just described, because I think it's really unique in a way to cover issues of transboundary water management governance from so many different perspectives in a coordinated, in a consistent form. So I'm really looking forward to seeing all of the volumes published. But let's dive a little bit deeper into that specific one, the one that focuses on, and is actually also called Cooperation over Shared Freshwater Resources Using International Law. And I'll hand over to Gabriel Eckstein. He is many things, but among these many things, he is a professor of law and the director of the Energy, Environmental, and Natural Resources Systems Law Project at Texas A&M University. He's also the current executive council of the International Association for Water Law. He also served as the legal counsel for Bolivia in, I guess, one of the most recent and one of the most famous international water law disputes that we've seen that is also actually covered in this volume. So Gabriel, you've been editing this specific book, this volume. Tell us a little more what's in it.
So thank you, Suzanne, for this introduction and warm welcome. And I want to first thank the audience, everybody attending, for joining us for this particular session. It's really exciting to see so many people interested in this topic. And I also want to thank Shlomi Dinar for inviting me to participate in this compilation. This has been a really exciting journey and a really educational experience, getting to learn about these topics, these specific legal topics from the perspective of the authors. So as was explained, the book is about cooperating over shared freshwater resources using international law. And what we wanted to do here was to convey two chief ideas, which really build on what Shlomi mentioned earlier in his remarks. The first one is that international water law really provides a framework for how states are supposed to conduct their activities and their relations with regard to the regulation, allocation, management, and protection of transboundary freshwater resources. And it also serves as a set of legal tools that nations can utilize when they seek to engage with each other, to cooperate, or to address disputes. Now, this can be used to address such issues, growing concerns around the world about water scarcity, dwindling freshwater supplies, inequitable distribution, ecological and cultural water priorities, and environmental changes due to climatic and other phenomenon. The challenge that lawyers and courts that we see globally is that we don't make it easy for non-lawyers to understand how these tools can be used. And we tend to use Latin terms, we tend to use archaic principles, and admittedly, we also use some vague norms. Equitable and reasonable utilization is one example of a norm that is often not well understood by non-lawyers. So one of the first ideas we wanted to present in this book is that we wanted to present international water law in a way that was accessible to the non-legal community. And so this book, this compilation of articles, is designed to give international water, or present international water law in a more clear and less technical perspective with less technical terms, but also in contexts that are less theoretical and maybe more practical. And the second chief idea that we wanted to work in here is that international water law does not operate in a vacuum. Its implementation, its operations, its concepts are functions of international diplomacy and relations, as well as the global political system. And in most cases, they cannot operate independently. So its application and implementation are intertwined within a host of other disciplines and fields, including, for example, international and regional relations and diplomacy, evolving scientific knowledge about the environment and freshwater resources, the role of indigenous communities in managing freshwater resources, and so on. So tying this point together with the first point and building on what Shlomi said, because in recognizing and appreciating this interdisciplinarity, this is where we believe the law can become more accessible, more understandable by the broader community. So in order to bridge the gaps between legal and non-legal disciplines, this book presents a series of original works that explore international law for shared freshwater resources using this interdisciplinary lens. The chapters included in the compilation do not simply articulate the law in any kind of particular circumstance. Rather, they offer insight into an analysis on how the law interacts and intersects with other disciplines in those specific contexts. Moreover, they critically examine the relative successes and also failures of the law to achieve the intended objectives. And finally, and while all of the authors are jurists, the chapters are written specifically with a broader non-legal audience in mind in order to allow for more diverse engagement and to encourage critical and interdisciplinary review of international water law. Now, I'm not going to describe each and every chapter in the book, but I do want to provide a brief overview of the structure of the book. The book begins with an introduction to the compilation and then follows with 2 chapters that provide the readers with an overview of an introduction into international water law. The next section of the book includes 6 chapters that parse out some of the most pressing, current, and emerging aspects of international water law, including what it means for nations to cooperate over freshwater resources, environmental flows, water security, the water energy food nexus, public participation, and indigenous and human rights. And then the final 3 chapters provide unique case studies about shared freshwater resources in North Africa, Southern Africa, South Asia, and Central America. Now, as individual chapters, the articles in this book provide unique insights into distinct aspects of international water law and its intertwined relationship with other disciplines. But as a collection, the book really offers broader and more complex insight into the concept of international water law and how its interactions with other disciplines are sometimes built on interdependencies that make the straightforward application and implementation of the law much more challenging. Thus, the value of this book is in its interdisciplinary approach to international water law as a function of international diplomacy, relations, and politics, as well as its effort to clarify and expand understanding of this distinct and challenging field. So today we're extremely fortunate that some of the chapter authors have kindly agreed to join us and offer their perspectives on their respective chapters, the overall book, and international water law generally. I'm extremely grateful to all of the authors who contributed to this effort, and I very much look forward to the discussion that follows. So on to you, Suzanne.
Thanks, Gabriel. Thanks for this great introduction, and also in the chat, all the participants. Just as a hint to you, if you go to the chat, you can see an overview or a list of all the chapters with the titles and the authors, if you already want to get a more detailed idea. And as Gabriel was just saying, we have some of the chapter authors with us today, and I'd like to now engage them in a discussion. I'll present them to you in a second so that you know who's talking to you. But just to let you know, the idea is that we'll first go from each chapter author to another and investigate what their main message is. So when writing the chapter, when thinking about the role international water law plays in governing shared water resources from the different perspectives that they're taking, what was the main message, or what was the main finding, the main thought they had that they wanted to contribute through their chapter to the book. And this was particularly important to us because, as Gabriel was just saying, this book is not meant for water lawyers talking to water lawyers, but really embedding international water law in the bigger picture for water managers, for practitioners, for diplomats, and so on. So my question to the panel will be what their key messages are, but let me first introduce the panel to you. We have Stefano Burci with us, who is very difficult to introduce because he's played so many roles, but I'll just highlight that he was a water law specialist with the FAO before, but then after he retired, he's been actually very active in the water law field still by chairing the International Association for Water Law, currently chairing the Water and Wetlands Specialist Group at the IUCN Commission for Environmental Law, but also authoring numerous books including a chapter in this book. So great that you're here, Stefano. We also have Gabriela Quadrado Quesada with us today, who's my colleague at IHE Delft. She's a senior lecturer and researcher here at IHE, focusing on water rights and water justice. Hi, Gabriela, great that you're here. We also have Otto Spijkers with us, who is an assistant professor of international and European law in Leiden University College, also here in the Netherlands, specifically at the Faculty of Governance and Global Affairs. He only joined Leiden recently, and before that worked actually on international law as a professor of international law at the Wuhan University, and there specifically China's Institute of Boundary and Ocean Studies. And before that was actually in Utrecht at the University of Utrecht, working at the Netherlands Institute of the Law of the Sea. We also have with us Amaka Udili. She is the director for legal affairs of the Federal Ministry of Justice in Abuja, but also, and that's why she's here with us today, a legal consultant who works on the Niger Basin and the various transboundary aquifer systems around it. So an aquifer specialist and an African water law specialist. And then we also have Amael Nutini, who is a legislative counselor to the Brazilian Senate. And from that very distinguished list of panelists that we have with us today, you can see that we really made an effort to bring together academics, practitioners, really have them talk to each other, have them evaluate the current situation of international water law when it comes to not only thinking academically about international water law, but really considering how international water law can play a role in managing our precious, our valuable freshwater resources, and dealing with the fact that they transcend the boundaries of nation states. And I'll start with you, Stefano, if you can share with us your main message, your main thoughts, what came out of your chapter and your contribution to the book.
Thank you, Suzanne. Happy to be in this distinguished group of fellow authors of the book. Now, the chapter that I contributed, that I actually served as the lead author alongside three fellow co-authors, Alice Orelli, Marina Rubio, and Thales Carvalho Rezende, at the time UNESCO staff, draws from and illustrates and draws from a personal experience with the fashioning, if you like, crafting of cooperation arrangements in two transboundary aquifers. One, the Stampriet aquifer system, shared by Botswana, Namibia, and South Africa, and the other, the Ocotepeque-Sitala aquifer, transboundary aquifer, shared by El Salvador and Honduras. Now, to make the story short, the sense of the chapter perhaps is that, and drawn from, as I said, hands-on personal experience and involvement, is as diffuse awareness among country-level decision makers of about the transboundary nature of an aquifer solidifies through incremental scientific cooperation, because that's where it all begins, and it all began also in these two particular transboundary aquifers. And as cooperation generates and fuels, also through training and other knowledge generation mechanisms, an awareness of cooperating in deference to international water law, there is a good chance that these processes escalate from the purely scientific to the policy and maybe even the political level, and trigger the will of countries to solidify cooperation through time and rest it on arrangements inspired by international water law. Now, these processes, which have been at work in the two aquifers that I mentioned earlier, and that are described in the chapter in the book, these processes in turn make up and contribute to the evolving incremental practice of states, which reverberates in turn and lend credence to international water law and strengthen its inspirational value and impact on the practice of states. And this sort of closes what can be seen as a virtuous loop that begins with scientific cooperation inspired by international water law and ends up crystallizing state practice, the state practice that informs and drives the incremental evolution of international water law. Thank you.
Thank you, Stefano. I'll hand over to Gabriela from your chapter, or should I say our chapter. What was the main message?
Thank you, Susanne. Indeed, this is our chapter. So in this chapter, what we discuss is how international water law and its core principles, equitable and reasonable utilization, no significant harm, cooperation, exchange of data and information, and prior notification and consultation have developed over time and in interdependence with both real world developments and scholarly discourses, including those, of course, outside legal scholarship, like hydrology, ecology, international relations, political sciences, and sociology, among others, that have also been key to develop international water law. So our discussion in this chapter, we conclude in the chapter, or the main message of the chapter is that international water law offers a valuable, however, an imperfect framework for states to govern and protect shared water resources. So within the chapter, our discussion focused on that while international water law was developed to prevent and or mitigate disputes over shared water resources by providing riparian states with a comprehensive framework on how to use, distribute, protect, and govern water resources, the regime is currently struggling to keep up with the rising challenges facing water resources worldwide. Therefore, the main message in the chapter is that international water law faces various challenges that threaten to undermine its relevance in guiding riparian states' behavior. So then we continue with the discussion of some of these challenges. And for example, we mentioned, or we gave a lot of importance to population growth and increasing demand for water, including for food and energy production, which are challenges that often are combined with the deterioration of the quality of available water resources, but also with the degradation of ecosystems. Then we move to another big challenge, which is climate change. And in here, we argue that this concerns in particular the need to deal with increasing variability of water availability. That means that in order to adapt this variability of water, many countries are increasingly developing their storage capacity. For example, using, among other solutions, the construction of dams and reservoirs. So co-riparian states in shared water courses are likely to be concerned about the impacts of the development of such projects, including on their own resilience to climate change. And therefore, this is likely to intensify the tensions between states over these infrastructure projects on shared rivers or lakes or aquifers, and this will test the conflict prevention and mitigation capacity of international water law. Thank you.
Thank you, Gabriela. Really interesting to see how this is a different chapter that focuses very much at the basin level, and we'll get to back to that specific basin level a little bit later. So you really see how the different chapters cover different topics and have different, yet I would say actually quite comprehensive and aligned messages when it comes to international water law. But let's hear from Amael. What's your main message that comes out of the chapter that you wrote?
Thank you, Suzanne. Well, when we discuss international water law, it's interesting to see that the state is and always was the main actor relating to the management of water resources. And but the same state is responsible for other obligations in international law, mainly human rights obligations that pertain to the individual. So we have two spheres of international law, one in which states interact in equal footing with other sovereign states, and other a realm of international law in which it has to comply with obligations with for people under its jurisdiction. So to try to join these two legal regimes, in the chapter we discuss a systemic approach to limit the state's discretionary power in allocating water in relation to the principle of equitable and reasonable utilization. We argue that it could not be seen as equitable and reasonable an allocation of water that would violate international law in other spheres of the state's responsibility. So a state would not be able to unilaterally allocate or dedicate its interests in water allocation to industry if it would violate the vital human needs of those populations, especially indigenous peoples that in the Inter-American region have been especially protected by the Inter-American Court of Human Rights, not only in the wide variety of needs that they have under this umbrella of the human rights to water and sanitation, but also in the due diligence requirements that projects have to follow in order to be implemented in an international water course. So our key message is that international water law should not and cannot be applied without consideration to other rules of international law that govern the state's obligations to their population and to the population of other states that might be affected by their operations.
Thanks. Thanks for highlighting this dimension that goes beyond the state, because indeed, as water lawyers, but I think also generally in the discourse, but also in many books that have been published on international water law, the focus is still very much on the state only and on state-to-state relations only. So I think this really adds a different and very interesting dimension to this. And we'll actually come back later to that specific question. Otto, maybe let's continue with you. Your key takeaway message that you want to send with your chapter.
Yeah, thank you, Suzanne. It's actually a little bit aligned with the previous presentation. So most of the authors in the book, they see a room for improvement in transboundary freshwater governance. Some call for decolonization of the governance system. Others for greenification, to pay more attention to protection and conservation of aquatic ecosystems. But me and Amuel seems to be doing the same thing. We call for sort of democratization and empowerment of some marginalized groups. So in my chapter, I look at participatory rights of local actors and communities in the freshwater governance. So the right to take part in decision-making relating to transboundary freshwater courses, I derive from a great variety of sources, including indeed the Declaration on Indigenous Peoples' Rights. So I take the dispute over the status and use of the Selala as a case study. So the Selala, for people who may not be aware of this, it's a tiny water source situated in the very sparsely populated and very hot and dry Atacama Desert. And the Silala, it flows from Bolivia into Chilean territory. I'm actually standing in front of the Silala right now. That is the Silala. That's the Silala River. So there was a dispute before the International Court of Justice over the status and use of the Silala. Suzanne already referred to it because Professor Gabriel Eckstein was actually serving as counsel to the state of Bolivia in that dispute, which led to a quite peculiar ruling, basically the court saying there is no dispute. But my aim is not really to analysis this ICJ ruling. So my point was rather that by initiating these proceedings before the International Court, all the attention was focused to the interstate aspects of the Selala problem. So I believe this caused what I call politicization of the dispute, followed by judicialization. So by politicization, I mean that the process through which a local issue suddenly becomes an object of national public contention and debate. And I argue that this is what happened to the Selala. So it could have been a merely local issue, but it was transformed into a national issue with all kinds of political aspects related to it. And then after the politicization of the dispute, it also became judicialized. And by that, I mean that courts and other judicial means are then sought to address this particular political controversy. So the latter, we also refer to it sometimes as lawfare, or maybe as a legal mobilization. So lawfare being a more derogatory term, and legal mobilization a more progressive and emancipatory term. So I use the term judicialization as a sort of neutral term, not taking particular position. So that is what my chapter is about, the democratization of freshwater governance with the Selala as a case study.
Thanks, Otto. As you can all see, yet another interesting dimension. You can really see how broad this book covers the topic of international water law. I think that's great. And then last but not least, I would like to turn to you, Amaka, for a summary of your key message, your key finding from what you contributed to the book. Can you? Yes, now we can hear you. Great.
Yeah, I said the title is Cooperation in Transboundary Water Context, the African Experience. It's actually addressed one major characteristics of shared water cooperation in Africa, and that's the regional perspective. That's the way it is, in spite of having the African Union, in spite of UNECA, United Nations Economic Commission for Africa. Regions of Africa, they've evolved the pattern, peculiar way of transboundary water cooperation in the particular region. For instance, in West Africa, you have basin-specific regimes. That's the way it operates. There is no regional water treaty. South Africa has regional water treaty under the SADC system, South Africa Development Commission. So you have the revised SADC water protocol. The Nile River Basin is another aspect. They don't have a treaty. Fine, we're almost getting there. But over time, they built a system of cooperating. Like now we have the Nile Basin Initiative as a major platform for cooperation. The Central Africa recently evolved a regional water treaty, the Shared Water Cooperation Convention of Central Africa. And I think particularly the regional bloc, economic bloc, emphasizes it because most of the water regimes, they evolve under the auspices of the regional water, of the regional economic bloc. For instance, you have the ECOWAS for West Africa. Though West Africa does not have a regional water treaty, we will have the regional water, the ECOWAS water protocol, which is though a soft law, but is somehow influencing water cooperation in the region, which mainly we have basin-specific treaties. The Niger River Basin, the Chad Basin, Senegal River Basin, they all have their water treaties. Then the SADC, South Africa Development Commission, evolved the SADC Water Protocol, the revised SADC Water Protocol. The East Africa, we have the East Africa Community, which developed or built the water regimes to like the Kagera Water Agreement, Kagera River Basin Agreement, and the Lake Victoria Water Protocol. They all evolved under the ECA, East African Community of Nations. So the summary of my work is my work addresses the regional perspective of shared water cooperation in Africa, despite having a continental body, the African Union, and the United Nations Economic Community of Africa. So in spite of all this, we still have progressed tremendously. Although the progress has been fragmented, it is not coordinated because each region does their own thing there. So my work I ended by emphasizing on what I call the pillars of water cooperation in Africa. In spite of the fragmented way we have cooperated, we have developed strong pillars of cooperation. What I term the basin institution has been of old. Actually, it evolved from the colonial roots of shared water cooperation in Africa. That's why the Act of Berlin that brought about the Congo River Basin Institution that existed until lately, when we have the SECOS for the Congo River Basin. Then we have the common works, the principle of common works, the principle of common public participation, integrated basin management, which over time, West Africa shared water cooperation has evolved from being a mono that's addressing particular issues like pollution, talking about institution and building of institutions, to integrated management of the transboundary water. And then Africa has also evolved peculiar way of addressing the human rights to water. So it's not only about human, but the Lake Chad Basin talk about the heading rights, also talking about rights of cattle to water resources in the shared water basin. So in a summary, like I'm thinking, do I have more to say? Because I have limited time to talk about what I have in my work, but I think I've addressed what actually, in a nutshell, what that chapter talks about: the regional perspective, the pillars of transboundary water cooperation, the colonial roots. Is actually the colonization that brought about shared water cooperation in Africa. So from the colonization, we have different countries evolving that were not there, and then the colonists started cooperating, and from there, after independence, we moved on. Then when we have the global water treaties, we have a better water treaties now than there used to be. Thank you.
Thank you. Thanks a lot, Amaka. That was very interesting. And I find it interesting to see how the book and all your contributions tackle different topics, but also how they actually address different governance levels and the linkages between them, right? We've heard about the very local level and how individual people's rights, but also communities' rights, indigenous people's rights, have to be and are increasingly incorporated in international water law. We addressed countries, we've talked about individual water bodies, be it basins of surface water or be it aquifers. But Amaka, you also just mentioned the regional level with the African Union, the famous SADC protocol, but also not to forget the Water Framework Directive here in Europe. And then, of course, we also have the global level with the two conventions, potentially at some point, maybe articles on aquifers, and then also, of course, the progress, if you want to call it like this, that has been made in the UN Water Conference last year. And I would actually like to zoom into these different levels a little bit in a second, but before that, I would like to remind everyone that you can pose your questions in the Q&A. So you'll find a little Q&A symbol at the bottom of your Zoom screen, and you can pose your questions there, and we'll actually take them up. And I've seen one already from Said Sadat that came in. Thanks, Said, for posing your question. I'll actually take that up right away when I'm turning to Gabriela. Gabriela, we have, well, you talked about the basin level, and I'd be curious, given that there has been so much attention, so much talk maybe in the last years about the global level, about the conventions, all of that. I'd be curious what you think is actually happening at the basin level, where it seems that a lot of decisions are actually being taken on the use, the management, the protection of water resources. So what do you think are the most decisive developments in basins? And I'd maybe like to link that, if possible, a little bit to the question that was asked in the Q&A, how international water law, specifically at the basin level, can actually play a role, given that some would say riparian states tend to prioritize their national interests. Gabriela.
Yeah, thank you, Susanne, and thank you for the question. Maybe I will start addressing a little bit what we discussed in the chapter. So what we mentioned there is.
Continue, I'll mute.
Can you please mute yourself? Thank you, Susanne. So what we were discussing is that specific basin level treaties have, thank you. So what we discussed is that specific basin level treaties have been fundamental in the development of international water law, because it is at this level, at the basin or sub-basin level, where riparian states really engage and come together and sit at the table in cooperation of shared water resources. So it is at the basin or sub-basin level where general international law principles and rules are really contextualized and adapted and put into practice. So this often occurs through the development of basin treaties and the establishment of river basin organizations as permanently institutionalized forms of cooperation. So what we were discussing in the chapter is that, for example, when we want to really come to the table and really make things happen, we have to go to the development of basin treaties. So we discussed that there have been mainly two waves of treaty development at the basin level. So one was in the 1960s, 1970s, and the second one was in the 1990s and 2000s. So in this first wave, we discussed that this was largely related to an increase in the state's interest to use and develop water resources, including, of course, those resources that they share with other states in order to foster economic growth. So this concerned, in particular, newly independent states. So example of this include the 1964 Lake Chad Basin Convention, which established the Lake Chad Basin Commission, and also the 1972 Convention creating the Organization for the Development of the Senegal River. So all these basin treaties exhibit a strong emphasis on the use of shared water resources for various economic sectors with the aim or the goal to foster economic development and, of course, to reduce poverty. So we continue to discuss that while that was happening in these newly independent states during this first wave, in Europe, there were also a lot of basin treaties growing, right? So we had this because there were growing concerns about the environment, where economic development was increasingly affecting the environment. So some of these agreements that we saw in Europe, just to give an example, is the 1962 Convention concerning the protection of waters of the Lake Geneva against pollution, which also established the International Commission for the Protection of Lake Geneva. So then we saw after this convention and after the creation of this commission that things really started to change, and there was really an improvement on the condition of the lake. Then another example in the European context is the 1976 Convention for the Protection of the Rhine against Chemical Pollution, advancing environmental protection in the heavily polluted Rhine River Basin. And again, this illustrates the trend towards an increasing focus on the environmental dimension governing shared water resources. The second wave, as I mentioned, there were two waves. This second wave, which started in the 1990s to the 2000s, was facilitated through broader developments. On one hand, we had the political change, including the end of the Cold War, which favored international cooperation and multilateral approaches. So example of this, cooperative opportunities arising from this geopolitical change include the 1990 Convention on the International Commission for the Protection of the Elbe River, and also the 1994 Convention on Cooperation for the Protection and Sustainable Use of the Danube River. So these two also established international commissions for the protection of the Elbe and the Danube River, respectively. So again, we saw at this basin level what really changes started to happen. So also the second broader development that we engaged in the chapter and we discussed that supported this second wave was an increasing awareness of the security implications arising from environmental challenges, expressed in the emerging environmental security debate, which influenced policymakers as well as academics in the water sector, which highlighted again the need to manage water resources in a cooperative manner. So example of this increasing cooperation due to this growing awareness of a need to approach water resources management from a basin perspective include the 1994 Permanent Okavango River Basin Water Commission Agreement and also the 2000 Orange Sengu River Commission Agreement. So these two treaties, again, illustrate the influence of hydrological considerations on the development of international water law regime, reflecting an increased focus on the protection of the entire basin, as well as the mainstream and the tributaries. So all these examples, what they are showing is that when we want to really make use or really put into practice these general principles, we need to go at the basin level, and then is where things start to happen, start to improve.
Thanks, Gabriela. I think that's an important point, right? We have different governance levels where international water law principles are being developed, where they're being implemented. But then what we have indeed seen, it seems, is that at this basin level with specific treaties and basin organizations, a lot has happened in the last years when it comes to managing water resources. Probably not enough if we look at the many challenges that remain, but I think a lot has happened. And I think that's an interesting segue to Stefano, because transboundary aquifers have not seen the same development. In fact, they've been a bit neglected, if we want to say it that way, when it comes to governing them. And there's actually only very few treaties that govern the many transboundary aquifers that are out there. So do you see any change? Do you see still important gaps when it comes to international water law and aquifers, or are you optimistic?
Let me put it this way. The groundwater aquifers and transboundary have been perhaps neglected because they are out of sight. But the experience tells, the recorded, the available record shows and tells that when managers, but lawyers, especially the scientists, put it this way, have mapped out the existence and the characteristics of aquifers, and have mapped out the characteristics of, in particular, transboundary aquifers and their existence, and the very characteristics, as I say, of transboundary aquifers have become known, and their features mapped out with the help of science. And also their economic and environmental significance have come to be appreciated and sized up. And stressful conditions have manifested, impacting on the quality and or on the regenerating processes of groundwater and aquifers. Then these, the legal system and the policy making system have responded to the challenges. So there is, there has not been, and I cannot detect an intentional neglect of transboundary aquifers, either by scientists or policymakers or lawyers, as much as perhaps how could I say, a purposeful attention and response whenever the transboundary nature of aquifers and the very existence of these aquifers and issues relating to and concerning the management, development, use, and protection of these aquifers have manifested, and the legal and the institutional legal system has responded. And there are, I mean, the examples that exist document this purposeful attention and response because they document the, how could I say, the that whenever problems have been documented, the legal system and the institutional system have responded to this. So I don't quite agree with the notion of a neglect, so to speak, or intentional, perhaps purposeful neglect of aquifers. Because, as I said, the examples that exist, and there are many examples, not many, I'm sorry, but there are many significant examples of response from the political system and the legal system to transboundary aquifers and problems and issues with their management, development, conservation, and use that attest to the fact that whenever, these have become known and problems have been appreciated, then there has been a response. Generally, that is the pattern, that one can see. Now, in terms of, gaps, you were alluding to gaps. And perhaps something, I mean, the legal framework for transboundary aquifers is quite, I would say, in addition to specific treaties and agreements that have responded to in different, to different degrees and levels of detail to the specifics of specific bilateral or multilateral aquifers. In addition to those, then at the global level, I would say we have a pretty good comprehensive coverage in terms of both the United Nations draft articles on the law of transboundary aquifers, which is non-binding, is a non-binding instrument, and also at the level of the other two major global instruments, legal instruments that are legally binding on the states that are parties to them, that address all surface water course, primarily surface water courses, but also groundwater. So the scope of coverage, I would say the coverage in terms of legal norms, substantive and procedural, provided by these various instruments at the global level is quite complete, I would say. It's quite thorough. It's but if there's a gap, quote unquote gap, that I could offer, for reflection, one could be a gap, so to speak, gap. One could be the fact that the chief instrument that addresses transboundary aquifers at the global level, i.e. the United Nations draft articles, is non-binding. So if you like, there's a gap there because this instrument is non-binding. So but I don't see personally at this particular stage much political will on the part of states, member states of the United Nations, to elevate this instrument to a legally binding level. So that to me is, for the moment, is a dead end. Perhaps there is a scope, in my opinion, and there is a gap in the legal mechanisms for the meaningful engagement and participation. This is something that resonates with something that was said and investigated in the chapters by both, and the remarks made by Natael and Amael Notini and Otto Spijkers. The engagement with and meaningful participation of local level stakeholders, not only state level, but local, intermediate, local level stakeholders, traditional communities and whatever, but not only in actual decision making regarding specific transboundary aquifers, but also in the negotiation of transboundary aquifer agreements. So upstream, if you like, engagement and participation upstream of formal agreement and downstream of formal agreement in the implementation of the agreement. So engagement at these two levels of local population is an area that, to my mind, is still, merits investigation and attention. And one final, issue that may be worthy of attention is the governance from a normative perspective, of course, is the governance of groundwater that underlies and is connected with the transboundary rivers and lakes. So this system of surface and groundwater, for which you find actually a limited response, a limited normative response at the level of transboundary river treaties and lake specific, addressing surface water courses. Whereas at the global level, you have a response in the various globally in the global instruments that I mentioned, but there's a risk there of, if you like, of competition and overlap, not conflict, but competition and overlap between the three major, legal instruments that I mentioned. Okay, I think I'll stop here.
Thanks. I think I mean, there was many interesting points, but I also find the reference to the conjunctive management quite interesting, because yes, there are river treaties that do even refer explicitly to groundwater, but if you then look at what has been done, or rather not been done, by the basin organizations that manage the basins and supposedly also the aquifer that's connected to it, I think that's the whole different story that might have merited its own chapter in the volume, but I think is certainly a topic that needs to be explored further in the future. So we're basically planning the next book here, I guess. But I'd like to move on to Amaka, because we've heard also from Gabriela that a lot of the developments and a lot of examples that Gabriela has mentioned actually referred to Africa. And we know that a lot of treaties that have been developed at the basin level were developed in Africa over the past decades. You've alluded earlier in your previous intervention to also the regional level. So I'm wondering if you can share a little bit more, in addition to what you said earlier, what you think were the most important developments. And I'm wondering, Amaka, if we can maybe relate that to two questions that we're seeing in the Q&A. One, referring specifically to your earlier statements, and asking whether it would be recommended for Africa to adopt a more beneficial use principle of water instead of focusing on the ownership of water. I think that's one element that maybe you can touch upon. The other thing that I find interesting was a question that was asked on climate change and the impacts it has on the arguments that upstream states in some basins potentially use in order to justify their infrastructure development, and the implications that potentially has on downstream states that might be suffering or that might see their rights harmed through such projects. So I'm wondering if, when you elaborate a bit more on the key developments in Africa over the last decades, you could maybe touch a little bit on these 2 points. Amaka. Please unmute yourself.
And the major key development in transboundary water course cooperation in Africa in the last 2 decades is actually the influence of the global water treaties in the shared water treaties that we have in Africa now. Prior to the inception of the global water treaties, the late 1990s, we had water treaties like the Act of Niamey, had the Lake Chad Basin Convention, the Senegal Basin Convention, the Gambia Basin. But with the evolution of water law, and then the evolution in the water law progress, and then we have the Global Water Treaties, the UNECE Water Convention, and then the UN Water Courses Convention. The UNECE Water Convention came as a regional water treaty. That's why I said, though we have in Africa, the United Nations Economic Community for Africa, it doesn't even address the continental water cooperation, unlike what the UNECE did in Europe. So with the inception of the UN Water Courses Convention, we have more treaties. I know revision of transboundary water cooperation regimes were evolved that actually reflected the principles of transboundary water cooperation. enunciated in those water treaties, in the global water treaties. For instance, we have the procedural obligations, substantive principles, the scope, addressing the scope of the water treaty that was actually absent in the previous instruments. Basin institution, more elaborated, and then we have different levels of dispute resolution as in the UN Water Courses Convention. Like we have major treaties, water treaties affected by those global water treaties, Niger Basin Water Charter, Lake Chad Basin Water Charter, the revised SADC Water Protocol that developed the SADC Water Protocol. Then Senegal Basin was protocol to the accord establishing the uniform river water regime of the Congo River Basin. The Congo River Basin had the Act of Berlin, 1885 Act of Berlin for many years, like almost a century, until the UN Water Courses Convention came and then influenced under the auspices of the UNECE too. And then the SADC Water Protocol. The Congo River Basin has a very modern water treaty now. So this is actually the major development we have in the last decade. Looking at South Africa, the provision of the SADC Water Protocol actually, as in the UNECE Water Convention, encourages basin-specific regimes in spite of the regional water instruments. So we have a lot of treaties in South Africa addressing specific nature of the river basins, like the Zambezi Water Course Agreement, the Kula, I can't even, some of them, I find it difficult pronouncing them. But what, in a nutshell, we have many instruments now in South Africa addressing basin-specific, the basin-specific characteristics of the river basin, according to Section 3 of the revised SADC Water Protocol that encourages river basins to have instruments, just like the UNECE Water Convention encourages basin-specific regimes that should be in collaboration in accordance with the provision of the convention. So we have different water regimes in South Africa that also are in harmony with the revised SADC Water Protocol that are addressing the specific needs of the river basins. So looking at the question that you asked on beneficial versus ownership of the river basin, it is actually the beneficial. That's why the principle of cooperation. What is cooperation? Like how do I put it? Described cooperation, defined cooperation. What is cooperation? Cooperation is nations coming together over a common resource to have to achieve a specific aim, specific purpose concerning that shared natural resources. This time it is water resources we are talking about. So it is ownership versus beneficial use of the water of the transboundary water. And I support and encourage beneficial use, not ownership, because ownership takes us back to the doctrine of you can do anything in the water because it belongs to me. It is within our region. Talking about the Hammond doctrine. Then we now go to territorial sovereignty, territorial integrity, and then the principles that encourage cooperation. So cooperation actually encourages beneficial use of water resources, that it benefits everybody that shared the water resources, both individuals and nations alike. And then when we look at the impact of climate change on the shared water resources, in Africa, there are principles that's particular principle peculiar to Africa that are not found in any other region. The principle of common works. And so when works are evolved in a river basin and it's made common and managed commonly, and so the issue of climate change on that water resources, the impact is reduced because all those structures that could have impacted negatively are managed by the river basin institution collaboratively. Like apart from the Senegal River Basin instrument on water, that's kind of the forerunner, the mother instrument on common works in Africa. We have the principle of common works in the SECOS. That's the SECOS regime of Congo River Basin. We have the principle of common works reflected in Niger River Basin Water Charter. We have it in the Chad Basin Water Charter. So you find that Africa is recognizing that if you want to develop a project in the river basin, particularly the project that will impact other nations, projects that will affect that will also aggravate the impact of climate change. It's rather termed common, so that everybody collaboratively to be managed by the basin institution, and so that the impact of that project, not every project, but there are some major projects in the river basin that should be common works, so that it will be managed collaboratively, it will be evolved, developed collaboratively, and reduce the impact of climate change in that river basin.
Thanks,
Thank you very much.
Amaka. Thank you. I think that's a very interesting point that indeed probably speaks to the question that was asked on how to deal with climate change in transboundary basins. The question, of course, being, which is why I think that was a very interesting question from someone from our audience, of course, relating to the questions if countries then indeed do it, because you referred to the Niger Basin Authority, where common works are a concept, but then if you see Niger and other countries taking projects such as Kandaji out of the joint plan and now implementing them unilaterally is, of course, maybe the opposite of what the common works idea was about.
Yes.
But I want to leave it at that for a moment, because I'd like to also take time to drill into the more local level, local communities, individual people, but also indigenous communities, and turn to both Otto and Amael. And I'll start with you, Otto. Where would you see the latest developments in international water law when it comes to including the voices of local people? What has there been any improvement, and if so, which?
Yeah, okay. I think I will be brief to allow for some Q&A, further Q&A. So actually, the short answer would be, please buy the book and read my chapter, and then you will be fully informed of the latest developments. So I'm referring to the Rio Declaration on Environment and Development of 1992. Okay, not very recent. There is a customary rule on public participation there. Then I look at the Helsinki Convention of 1992 and the Watercourse Convention of 1997. And I am very disappointed in those two, because there's not very strong language about public participation there. So then I turn my attention to human rights law. I look in particular at the General Comment 15 of the Commission on Economic, Social and Cultural Rights of 2003, which has a large paragraph on public participation. And then indeed, I look at the UN Declaration on the Rights of Indigenous Peoples, so not individuals, but people's rights. But I think Amael is the expert here. That was adopted in 2007, if I'm not mistaken. And then finally, I also look at regional environmental law, and that's maybe the latest development, because my chapter is about Bolivia and Chile. So I look at the regional agreement on public participation in environmental matters in Latin America and the Caribbean. So that's the Escazú Agreement, named after this beautiful city in Costa Rica. Well, I've never been there, but the pictures look very nice. So it was adopted there in 2018, but it only entered into force in 2021. And for my particular case study, it is very interesting to look at Chile's behavior. So Chile was actually one of the main sources of inspiration, one of the principal drafters of this agreement. But then, exactly because of the dispute they had with Bolivia, they refused to ratify it for a long time. So Chile only became a party to that agreement in 2022. Bolivia was already a party since 2019. So from then on, it became relevant also to my case study. Yeah, and of course, yeah, that is the most recent development, I guess, in public participation. So the problem is not that we are lacking in rights. Yeah, the problem is more implementation of these rights. I don't think we need more participatory rights at the global, regional, or even domestic level. We have plenty of law. No need for more law.
Yeah, but indeed the question, what do we make of it and how do we implement it? I think that really is a key point that the book also in various chapters addresses, but I think definitely more research is needed on that. Amael, specifically when it comes to indigenous communities, what's your take on that? Have we made progress? What have been key turning points?
Well, I do believe that we made progress on an international level, but basically on human rights, not on international water law. When we discuss human needs in international water law, taking into consideration the United Nations Water Convention and the draft articles on the law of transboundary aquifers, we're talking about very scarce human needs, the needs that are necessary for basically the human survival. But we can try to pinpoint this discussion in the time that it was conceived. These instruments were drafted before some of the most relevant developments in the human rights to water and sanitation. So not only we can try to apply a systemic interpretation to convey the human rights in the interest of the state when allocating water, but also we're broadening the sense of what human needs uh, are in the context of international water law. And for indigenous peoples, that would be not only those for a dignified human life, but also those of a cultural dimension in relation to water, and also in relation to their ancestral relationship with nature. So we are trying to develop theories to address some of the omissions we have in international water law. Because even in the instruments that are inspired in those broad frameworks that we discussed, we do not tackle human rights. And even if we do have law, we do not have instances where this law is applied. And the Inter-American Court of Human Rights has expanded a little bit its jurisdiction in recent years to address environmental law as human rights within its jurisdiction. So we may, in not a very distant future, see interstate disputes in human rights courts. And not only on human rights, but on issues related to human rights, such as the environment. Because most of these international instruments have some relation to the enjoyment of a dignified life. So we have possibilities of obligating the state to comply with these new aspects, but we do also have challenges, mostly political challenges, relating to the compliance of these obligations, even if they are ruled by an international court, because we have been seeing a backlash in the Inter-American Court of Human Rights due to this expansion of jurisdiction. Of course, we do want to expand international water law to encompass human rights, but one of the elements that caused the late development of the human right to water is that several states had reservations about what a human right to water would imply to their sovereignty. They were afraid that the human right to water would imply that they had to share more water than was actable or reasonable with other states. So if this is at some level the sovereign will of the state, it is also the state, the current affairs in international water law, and that is something that is open for the will of the states and not the will of the individuals, because international law emanates from states. But in any case, we have some instance of cooperation, and I think the way to make human rights present in international water law is through this the insertion of these mechanisms of participation, is through the local level and basin organizations that incorporate this vision of human rights in the application of these international norms. And it's certainly not an easy task, but it's one that I think this book contributes in order to achieve that goal.
Thanks, Amael. I want to come to one question that was asked earlier in our webinar, because we've actually been talking quite a bit now about humans, human rights, rights of individuals, rights of indigenous communities, and I'm very happy that the book covers a lot of that. I think what it doesn't cover enough, maybe, so again, idea for the next book, but something that we're generally not covering sufficiently in the international water law discussion, at least in my opinion, is the question of non-humans. It's ecosystems, it's aquatic species, it's aquatic life and their own rights. And there was a question earlier asked by someone from our audience, how we as a group of authors, and I'm thinking maybe Gabriela, maybe Stefano or others want to reply to that. What's our take on developments in international water law when it comes to water themselves, be it water quality challenges, be it challenges to aquatic biodiversity, which we all know is the fastest declining type of biodiversity in the world? Any thoughts on that briefly, please, because we're running out of time, but I'm thinking maybe Gabriela, you have an idea on that? You have to unmute yourself, Gabriela.
Sorry. Yeah, I think we also discussed that a little bit in the chapter. And what we said is, like, for international water law, we need to engage with new theoretical concepts. So we mentioned, even we give some examples of some that we think it could be useful. For example, we mentioned air system law, which aims at advancing international water law more fundamentally and moving it from a human-centric point of view to a more ecosystemic-oriented approach. So that is something that I think would be interesting to look at. So this idea of air system law attempts to ecologize environmental law in order to protect the intrinsic values of nature independently from humans. Those could also hold promising suggestions for international water law, right? So we also mentioned the other theoretical development that we mentioned is the idea of rights of nature, which has its origins in indigenous knowledge and ancestral cultures, which we could also revise and engage and use as an inspiration for the future of international water law. And I will keep it here just to because of time constraints, but yeah, I think that could be some things that we can really discuss much more.
Thanks. I'm wondering if someone else from our panelists would like to add and maybe also include another question that was just asked, because it's of course not only current generations, it's not only past generations and ancestors, it's not only non-humans, it's also future generations. So any thoughts on how we can reconcile all of those? I see, Amael, you have a thought on that.
Yeah, actually, that, in my point of view, is also a challenge for international water law, because the equitable and reasonable utilization principle only covers intrageneration equity and not intergeneration equity. It was a big discussion at the time of the drafting of both instruments. And I think that the insertion of human rights perceptions in the application of international water law is a way of opening the door to intergeneration equity, because we're thinking of human rights not only in a view that pertains to the rights of an individual, but we have human rights that pertain to nature, even if the individual is not harmed by a harm to the environment. That is the view of the Inter-American Court of Human Rights, and it has also been established in various bodies of international law. And I think that these developments on the rights to the environment and its interrelation with the right to water may open the door for the discussion of intergenerational equity, but I think we're not quite there yet, but maybe we can be in a near future.
Thanks, Amael. Amaka, would you like to add, and can you please do that in less than 1 minute in the interest of time?
Yes, I want to add that we should encourage basin treaties that encourage function, that encourage integrate, that has encourage address integrated approach to managing shearwater costs instead of functional approach that deals with particular problem and then leaving the other ones. Because integrated approach of managing water resources takes care of everything. It's holistic, takes care of the ecosystem and everything in that shared water cost. But when you deal with a particular problem, because over time, I found out that international water law has evolved tremendously. Oh, before it was functional, dealt with pollution. For instance, Helsinki rules, we look at regimes, in the past regimes, even in Africa, they were very functional dealing with particular issues. If you look at the Nile Basin treaties, the colonial treaties of Nile Basin dealt with issue of irrigation, much right given to Egypt. Look at the South Africa, it was power, irrigation, and so on. But now we have treaties that are holistic, they're integrated. So I think if we have holistic regimes, if actually apply the principles in those integrated water regimes, we will not have problem of non-human instruments not taken care of. The ecosystem will be addressed properly in the water instruments. That's my take here.
Thank you. Thanks, Amaka. I think there's many more topics that we could discuss. We've really only scratched on the surface. Maybe we need a webinar for each of the individual topics that we have addressed. But this is, of course, also an invitation for all of you to read the book, engage in a discussion with all of us. And hopefully this was only the start and not the end of a discussion on this important topic. But I would like to now hand over to Gabriel Eckstein for his closing remarks, not before I have thanked all the panelists, Stefano, Gabriela, Amaka, Amael, and Otto, for your contributions. Thanks a lot. And over to you, Gabriel.
Thank you so much. This has been such a rich discussion. This is, as an editor, for a book like this, it is so exciting to see the level of depth that is that can come out of this kind of conversation, that in reviewing the chapters, basically I'm very biased because I'm the editor for this book, and I think this is an excellent compilation. But I have to say that based on this conversation we've had here, I think this gives you an example of how this is such a fantastic field to explore and also to engage in, especially when we make it more accessible, when we invite the interdisciplinarity, we invite the other fields to sort of engage in the conversation. The breadth of topics that have been covered here has been so fantastic in terms of cooperation, human rights. I was just trying to write all the different topics, relationship between upstream and downstream, relationship between domestic international law, the role of numerous regional and global conventions, and so on. Just such a wonderful conversation, but it doesn't mean that there aren't gaps in the system. And I think some of our participants really highlighted where some of those gaps lie. And there's a number of questions that we didn't get to. I just want to highlight one of them, on transboundary aquifers and how to ensure the environmental protections. We have aquifer-dependent ecosystems, environments that are dependent on either the springs that come out from aquifers, or actually we have environments within, for example, karst aquifers, which actually have sort of cave and cavern systems within the aquifer system. And how do we protect that? And to a large extent, we can rely on the generic principles of international water law, but they're not really tailored to the scenario of groundwater. And so there are gaps in the system, like in this particular one. And so it's not always possible to just point to international water law and say, okay, it can be fixed, it will be fixed, and here's a solution. But it's really wonderful to see this coming together. And I really want to thank Shlomi Dinar again for inviting me, for participating in this effort, coming on this journey. And I really want to thank also all the authors, some of which you met here today. There is another, what, 7 or 8 or 9 authors who are not able to, we just couldn't squeeze everybody on the screen, but they're coming from all over the world, from all the different continents around the world, covering different thematic topics, case studies, and so on. And so really excited and really pleased with the way this book has come out. I also want to thank our partners in this program that have so graciously supported us. Of course, the International Association for Water Law and IHE Delft Institute for Water Education taking the lead on coordinating and organize this event, but also the partnerships we received from the Texas A&M School of Law, Florida International University, Stephen J. Green School of International Public Affairs, and of course, this would not have happened if the World Scientific Publishing wasn't a part of this and providing the opportunity to publish this work. I know there are other questions that have been posed in the Q&A. I see some hands up, but unfortunately we are out of time. I would encourage you to please feel free to contact us in our individual capacities. I'm happy also if people want to contact me, and I can direct you to the chapter authors if you have specific questions for particular authors. And of course, I also encourage you to take a look at the book, purchase it, and then, as Suzanne and others said, there's a lot of topics that remain unclear and unanswered. And so maybe we will get to a second book. Please bring us your ideas. Maybe you will join us in writing some of these chapters. But thank you all for joining us here today. Really a wonderful presentation. Thank you all for the participants, the speakers, and I wish you all a wonderful week. Take care.